They handed me papers and said, "Sign or we don't release your car." A $20,000 penalty. If I sold it within a year, I signed because I had no choice. And then I sold the car. 2 weeks later, the dealership's lawyer emailed me a demand letter. What they didn't know was that signing under pressure was the start of their undoing. Stick with me. This is how a scared little clause turned into a full-blown corporate mess. If you like watching Power Flip, hit like and subscribe. I read every comment. Today's story is about staying calm under pressure, collecting receipts, and using other people's arrogance against them. Now, here's how it all went down. If you'd like to share your story with our channel, please send it via the email link in the description. I'd been waiting for that G63 for months. This was not an impulse. It was a planned purchase, down to the exact paint color and the coffee-stained notes in my phone with the VIN. I ordered the Mercedes early in the year, tracked the shipment obsessively, and when the call finally came that it had arrived, I felt the distinct, quiet joy of something I'd worked for. But the joy curdled the moment I walked into the dealership. The salesman I'd dealt with suddenly became theatrical. Forms appeared on the counter like magic. There was the typical smell of new car leather, but behind it, there was also the faint, greasy scent of impatience. From them, not me. After I secured financing through my credit union, the manager called and said there was an issue, and they might have to cancel unless I signed an additional form. The form was simple in text and vicious in effect. I agreed not to sell the vehicle within the first year of ownership, or I would owe a $20,000 penalty. They told me it was standard for certain orders. I'd never seen that before. And when I asked for time to review it, I was told bluntly, "Sign now or we don't release the truck." The seatbelt clip felt too heavy across my lap. I felt cornered. I signed. There's a very specific physical memory I have from that moment. The way the pen clicked across the paper. The receptionist's indifferent smile. The key handed over with an almost theatrical flourish. I drove the car home with my hands wrapped tight around the wheel. Not because I was thrilled, but because I felt oddly hollow. Something about that. Coercion sat in my chest like a stone. I felt forced to sign. But that pressure would later be the evidence I needed. Life changed in ways I didn't expect. Within months, my personal circumstances shifted. A job relocation, family expenses ballooning, and an unexpected medical bill that took a chunk out of my savings. I'm not someone who brags about money. That's never been my style. I bought the car knowing I might sell it if life required. That's a reality. For many of us, when I posted the G63 for sale at a small loss, I didn't imagine it would be a problem. Then the email arrived. An attorney for the dealership sent a crisp, formal demand letter. Pay $20,000 for breaching the 1-year clause or face further legal action. The phrasing was polite on the surface, but menacing underneath. There was a chilling line near the end. "We reserve all rights." My stomach dropped like I'd been pushed down a flight of stairs. I called the dealership. The manager's voice was empathetic and firm. "We told you about the clause." He kept repeating that the form was agreed to. I told them I felt pressured to sign. He deflected. That was their play. Create the illusion of consent, and then weaponize the paperwork later. I could have panicked and paid, but I didn't. Panic doesn't solve coercion. Strategy does. I sat at my kitchen table surrounded by the vehicle's paperwork. Purchase order, emails, financing documents, and that awful clause. I made a small ritual that felt childish but strangely empowering. I laid everything out like evidence in a case. The line-by-line details became my scaffolding. One thought kept surfacing. They shouldn't be allowed to bully people like this. I wasn't interested in making a fortune off anyone. I just wanted to be treated fairly. That legal demand letter was not only about money, it was an attempt to weaponize a coerced agreement that was the breaking point. I called a friend who works in contracts. She said 2 words that made my palms sweat and my chest clear. Duress, get a lawyer. Duress. The idea that what I signed might be invalid because I was forced into it felt like a light switching on duress was my opening. But using it would require a plan. I needed an attorney who didn't just nod. Someone who would go on offense. I did the boring, meticulous work. I called 3 lawyers, compared fees, and chose one who specialized in consumer protection and contract law. Her first question wasn't dramatic. Show me everything. She wanted the timeline, the calls, the personalities. She wanted to know how I'd been pressured. We created a simple timeline. We subpoenaed records, emails from the dealership, any internal notes about the order, text messages, and the sales associate's notes. My lawyer also advised me to document the dealership environment, recollections of the conversation, the receptionist's expression, the exact phrasing used. We recorded statements, gathered witnesses. The person who'd financed the vehicle for me had texted me confirmations. The dealership had sent paperwork in stages. Not everything was airtight on their side. My lawyer filed a demand for the dealership's communications and also reached out to a consumer protection group that had handled similar cases. We considered a counter notice, a preemptive legal memo outlining the likelihood that the clause was unenforceable under duress and unconscionability. The strategy was clear. Don't only defend. Start to expose the dealership's practices. I also quietly reached out to a local consumer journalist I'd met through a community group. She asked pointed, skeptical questions, and I answered plainly, no, melodrama, just facts. I was told to sign or they wouldn't release my car. I called later and asked to rescind, and they refused. She said she'd look into whether this was a pattern. We'd built a legal and public front. Next was execution, where the pressure would flip to. Then we served a formal legal notice asserting duress. Coupled with a demand for arbitration to be put on hold simultaneously, the journalist ran a small piece online about dealer addendums that bind customers and used my case as an example. The dealership panicked. The attorney who had sent me the demand suddenly became more conciliatory. They offered to negotiate rather than drag it to court. That negotiation was the first sign that our combined legal public strategy was working. Our lawyer pushed. She filed requests for internal documentation. She made clear that if the clause was a standard practice, we would pursue broader remedies and involve regulators. The Texas Consumer Protection Office got a courtesy copy of the filings. That's when the dealership shifted from confident to defensive. They called me, but not for empathy. The dealership's PR person wanted to resolve things quietly. Their tone betrayed fear. Money hadn't even changed hands yet. It was the specter of an investigation and possible regulatory action that made them flinch. They wanted quiet. That's when we turned. The quiet into leverage during a mediated call. The dealership tried to offer a small settlement, less than half of the penalty, and insisted on confidentiality. My lawyer said no. We had leverage, proof of coercion, a journalist already sniffing around, and consumer protection eyes. The dealership's options were dwindling. Then, the PR misstep happened. A local consumer watchdog posted a notice about a pending complaint with the dealership's name. Conversations in the industry forum started trending. Watch out for Texas. Dealer addendums. Dealers prefer silence. Panic spread like an oil slick faced with potential class action exposure or a regulatory audit. The dealership folded in the most unceremonious way. They retracted the demand, agreed to rescind the $20,000 clause, and paid a small settlement to cover my legal fees. They insisted on non-disclosure, but by then the journalist's piece had already quietly mentioned a similar pattern in the region, and the forum posts had done their damage. Foot traffic to their lot dropped for weeks. It wasn't a dramatic courtroom finale. It was a slow leak, a series of disclosures that made the dealership's tactics visible and costly. They'd gambled on intimidation. I'd gambled on patience, paperwork, and public accountability. The stakes shifted, and they lost. There's a strange satisfaction in watching a giant flinch. Not because I wanted to punish someone for the sake of punishment, But because I wanted the system to treat me fairly, signing under duress felt like a violation. Fighting back felt like taking back my dignity. I'll be honest. The settlement didn't feel like a victory lap. I didn't get rich. I didn't even fully get my money back on the car sale. But I did make that dealership think twice. I turned an abusive clause into a public example and, I hope, saved someone else from the same trap. If there's one practical thing I went away with, document everything. If you feel pressured, note names, times, and exact words, and get legal advice early. The moment someone says, sign now, or we keep the car, that's not a hiccup, that's a red flag. If a story like this hit home, hit like and subscribe. Have you ever been bullied by a company? Tell your story in the comments. I read them all. If you want, check the pinned comment for resources about consumer protection in Texas. See you in the next one. The G63 sits in my past now. A car that brought equal parts joy and headache. I sold it to stabilize my life. The dealership? They still sell cars, but for a while their lot felt quieter. For me, it was never about revenge as entertainment. It was about refusing to be bullied, and about proving that an apparently unbeatable clause